Okay, welcome to Core Law, 3 hours of continuing education. This is going to be an update on Florida real estate law. So why don't we go ahead and get started? To begin with, we're going to start out with escrow accounts. An escrow account is simply a place of safekeeping. And let me explain that. It could be located anywhere that a buyer and seller chooses, as long as the money or whatever is being held is not in harm's way, or that is, could be lost. It could even be in a safety deposit box if the buyer and seller knows and agrees to it. If the broker is holding escrow, he or she is considered to be the signature of that account. In other words, they're the ones that can write a check on that account. They're in complete control of that account. Some of the locations that a broker can place escrow and be the signature would be a commercial bank, a credit union, or a savings and loan. A broker could, in fact, turn the funds over to a title company or an attorney, in which case they will be considered a non-signature on that account. In other words, the broker does not have control over that account. Rather, the title company or the attorney that's handling it has total control over those funds. A broker can use up to $1,000 of personal funds to open an account for sales and up to $5,000 for property management. Sales associates and broker associates must deliver earnest money deposits to their broker within 1 business day of the date that the contract calls for delivery. The broker has 3 business days to deliver the escrow based on that same date. In other words, the date that the contract says the money is tendered, the sales associate has 1 day, 1 business day. The broker has 3 business days. The broker does not have an additional 3 business days. In other words, the meter starts to run the same for both. If notification by title company or attorney to deliver the earnest money has not been received by the broker within 10 business days from the date the funds were delivered, the broker must notify all parties in writing that the receipt of funds has not been provided. Trust liability is the amount of funds the broker is supposed to have in a trust account, with unposted deposits and outstanding checks factored in. Conflicting demands occur when parties to the agreement all are making demands on the earnest money deposit. There are 4 methods that the broker has to resolve conflicting demands, and that is mediation, arbitration, an escrow disbursement order by the Florida Real Estate Commission, and litigation. But remember, this can only occur when the broker is the signature of the account. The minimum requirement for the name of the licensee in any advertisement is their last name as they're registered with a DBPR. Team or group advertising cannot exceed the size of the brokerage name or logo. The minimum requirement information for advertising is the name of the brokerage entity. The minimum requirement information for point of contact advertisement, that is internet-based advertisement, is the name of the brokerage business, the broker's address, the telephone number, and an email address. Now, the telephone number and email address can be of the associate, but the address and the brokerage name has to be of the brokerage. Florida Statute 475.161 allows associates to form and operate as either a professional corporation, that's a PC, a limited liability company, an LLC, or a professional limited liability company, PLLC. And these are the only options that a licensee has to operate when practicing real estate. Only a broker can operate in a fictitious or unnatural name. The agency relationship that offers fiduciary relationships is a single agent relationship. And remember, the broker can either represent the buyer or the seller, but cannot represent both in the same transaction as a fiduciary. The 2 agency relationships that are considered to be facilitators are transaction brokerage and the no brokerage relationship. The 2 agency relationships that offer skill, care, and diligence are single agent relationships and transaction brokerage relationships. The only document or form in the disclosure of agency that must be acknowledged or signed is when a broker is transitioning from a single agent relationship to a transaction brokerage relationship. In Florida, brokers and sales associates are presumed to be transaction brokers unless they enter into a written relationship, that is an agreement, for another type of agency. The transaction brokerage relationship offers limited confidentiality, which means that in negotiating, a broker or an associate should never promote one party's position or interest over the other, giving one an advantage over the other. A designated sales associate can only occur in a non-residential transaction within one broker's office where both buyer and sellers have assets of at least $1 million or more. Florida Commercial Real Estate Sales Commission Lien Act allows brokers to file a lien against net proceeds in a non-residential transaction for commissions earned. Lien privileges are spelled out in commercial listing contracts and in commercial lease contracts. The Community Planning Act moved land development and growth management from the control of the state of Florida back to local governments. Florida Residential Landlord Tenant Act requires landlords who choose to commingle security deposits with personal funds to post a surety bond with the clerk of courts in the amount of the deposit and pay the tenant 5% interest for the use of their money when the lease terminates. Landlords must notify the tenant within 30 days of the termination of the lease by certified mail the detail of any monies that will be retained for damages. Military and low-income individuals are exempt from application and renewal fees imposed by the DBPR. And that is the end of our review for core law.